we're going to end it there. Anything else?
No other questions, Judge.
All right. So for the record, the objections overruled. Any questions for the witness?
No, sir. Thank you.
All right. Thank you for your testimony. You can go in the gallery or go about your business. I'm fine either way. Thank you.
State has no other rebuttal evidence, Judge.
All right, folks, very appreciative of your time. You certainly given a lot to your community, and we very much appreciate that. The next stage will not occur this evening, but the next stage is closing arguments. I have no idea how long they're going to be. But typically, it's a bracket of 2 to 4 hours, so you can do the math. If we were to do it now, we'd probably be here till about 7:30, 8 o'clock, and then I'm going to read to you approximately 25 to 30 minutes of the law as it relates to this case. I need to speak with the lawyers, and we did some of that last night. I need to speak with the lawyers again about what I read to y'all. So there's no point in us going till 9 o'clock tonight. So we're going to release you today, come back at 9, and we're going to start with closing arguments. I would like to start punctually at 9, so I'm going to tell you some things that I would tell you then, I'll tell you now. You may be familiar with other types of closing arguments. This is a real case. Typically, the state will give a introductory closing argument, and then sandwiched in between, the defense will go, and then the state will go again. That is common practice in Georgia. So you're likely going to hear from the state at first, and I'm not telling you how long they're going to be, but roughly 30, 45 minutes, roughly. And then the defense will go, and then the state will come back, and then I will read you jury instructions, and then you'll be released to deliberate. The evidence in this matter is concluded. All that remains is argument from the attorneys. Appreciate your patience. As always, do not discuss this case with anyone. Do not perform any research. Do not go to the scene. Do not go online, paper, books, AI, none of that stuff. With that, thank you for your time. We'll see you back tomorrow morning, 8:45, 9 o'clock. Thank you. Thank you. We'll rotate to charge conference in a moment.
And just while we're moving for a directed verdict, Judge, we have a brief in support of that, which Mr. Bullard has prepared, and we'll be handing copies to the court and to the state. It is in support of our motion for directed verdict.
So we'll be, y'all can sit, stand, wherever you want to do. I have no idea how long this is going to be. If I had to guess, I would say a half hour plus or minus. So we're going to conduct a legal motion. Again, I'm not putting any limit on anyone, but I anticipate this could be a half hour. Obviously, sometimes I'm wildly wrong, and it could be 5 minutes or it could be 2 hours. We just had a break, so I'm not inclined to do another break, so we'll roll right into legal matters up to and including any additional from the defense, any additional from the state, and then we will rotate into charge conference as well as some administrative issues that we probably need to address. Defense, floor is yours.
Your Honor, may I approach the brief?
Thank you.
Judge, I'm confused. We've already had a directed verdict argument. It's already been denied.
Your Honor,
This is, we've already argued a directed verdict at the close of the state's case in chief, The defense has already had their opportunity to argue a directed verdict, and Your Honor's already given a ruling on a directed verdict. I don't understand why we are now having this argument after the defense's case in chief.
Your Honor, if I could point the court to page 2 of the memo, where we deal with an anticipated objection that we did not raise these specific grounds earlier. OCGA 1791 says that we may move for a directed verdict. Sorry,
It's not your fault.
all right.
Everyone's working, and I appreciate that. Go ahead.
Either at the close of the state's case in chief, or, but since it's cast in the disjunctive, there's no reason we can't do both. In addition, a motion for directed verdict in Georgia is essentially a challenge to the legal sufficiency of the evidence, which is not something that as a constitutional matter can be waived. It can be raised at any time that it is ripe, and it is ripe right now. So it is not that we were entirely allowed to defer this, to wait until the close of the evidence to see what all of the evidence was.
Procedurally, I think you're correct. I'll hear from the state. If you want to take a break, that's fine too, but I do believe procedurally you are correct. Making no comment one way or the other on the substantive portion of it.
I mean, it says or, it doesn't say and or. It says that they can move for a directed verdict at the close of the state's case in chief or later if they fail to do it before. It
Your Honor,
doesn't say both. You get to just continue to do it.
Your Honor, often in statutes, when things are cast in the disjunctive, it means they are in the, not only in the alternative, but it means that we can do both. I would point out that the state, as a matter of sort of opposite points, the statute dealing with when the state may open and close, it says the state may open and close, and the state often waives their first opening. The fact that it's or does not mean we can't do it at this time. It's not a waiver issue. We have long since done away with waiver issues on motions, on directed verdict motions, that you don't waive it by not raising it earlier, that you defer it, that it can be deferred. There's no reason we can't raise these issues now. What's more, since it is a sufficiency argument, the court could hear it at the motion for a new trial and still strike the matter. In fact, it's in the interest of judicial economy that we go ahead and resolve these questions now. So the court is entirely within its power to grant a directed verdict at this point, and we're providing the information to the court for it to do so. And there's absolutely, there really is, I really don't understand Ms. Bennett's argument. Simply because we have the option of doing it at one or the other does not mean we can't do it at both.
Well, I imagine that you do understand her argument, you may disagree with it. So, all right. If the state wants to address it later, that's fine. As of right now, I'll authorize it. Go ahead.
Thank you. Your Honor, I'm not going to talk about...
To be clear, procedurally, go ahead.
I understand, Your Honor. Your Honor, I'm not going to talk about every count in the indictment. We're going to submit entirely to the court's discretion without argument. What I would like to talk about are specific issues within counts 2 to 5. I want to look at those in two groups. All right.
Go ahead.
First, I want to take the first group are those counts related to, or that are predicated on aggravated assault, which would be counts 2, count 4, which is the aggravated assault charge itself, and count 6, which is the possession of a firearm during the commission of the aggravated assault in count 4. The second group will be the counts dealing with the criminal damage, so the odd counts, the count 3, which is the felony murder predicated on criminal damage, and on count 5, the criminal damage itself. Our argument as to, and I'll say in no case, as to those counts, are we asking for the court to strike the counts in their entirety. But 1791 authorizes the court to grant partial relief, to allow the case to go to the jury on lesser offenses. And that's what we're talking about here. Actually technical matters of proof. So, we have been talking since before the beginning of the trial as to the aggravated assault counts. that there are two species of assault. The Supreme Court has said repeatedly that an aggravated assault is some form of simple assault plus an aggravating factor. I know we've been talking about it. It raised its head yesterday in the charge conference. We brought it up at the demurrer, and it's relevant here. The law is clear that an A1 assault, the attempt to commit a violent injury assault is a specific intent assault plus the act that is attempting to commit a violent injury. So basically an attempted but inchoate battery. The A2 assault is a general intent crime. It requires one to intend to act in the assaultive manner, and this is where we draw our line in the sand, that the victim be shown to have reasonably apprehended the assault. As to the assault counts, we are asking that they go to the jury on nothing more than an attempted injury species of assault. We do not believe that the state has provided sufficient evidence for the jury to infer that Mr. Barron anticipated the shot that killed him. And I know, I can feel it behind me. There's some tension here because he did get hit. He absolutely got hit and he was killed, but the striking and killing is not the anticipation, as the Court of Appeals made clear in Montford versus the state. Montford is cited in our motion at 254 Georgia Appeals 524. What's interesting about Montford is that both species of assault were in play. It was an aggravated assault case, aggravated assault against a law enforcement officer. The undisputed evidence is that the defendant, Montford, struck an officer. The undisputed testimony was that the defendant, Montford, was not looked up and did not realize until the last moment that there was a car in front of him. So the undisputed evidence was that he did not have the specific intent to commit the assaultive act, which ruled out the A1 assault. The officer, the victim's testimony was that he did not perceive the assault, he did not perceive the car until he was hit. So it is the apprehension that is the essential element. Here, we have a shot passing through the door. That's what's in the indictment, that's what the evidence was. We have a shot passing through an opaque, can't see through it, door. And the undisputed evidence shown in by Dr. Zhang and Investigator Durham's display, I think it states 181, if I may. Just for sake of using the Elmo, if I may. Make sure I've got this. The shot, Your Honor, comes through the door, through the wall, and into Mr. Barron's left side. If that is his left side, he is facing away from the direction of the shot. So we do not have visual perception of the shot. I'm going to put this back. So that leaves us with oral perception of the shot. The court can take judicial notice that the speed of sound at sea level is 1,225 feet per second, and 1,225.538 feet per second. Your Honor, the bullet leaves the end of the Glock faster than the speed of sound, and it travels an incredibly short distance. Dr. Zhang, when asked, said she couldn't say whether Mr. Barron would have perceived the shot beforehand, but the evidence came in under Rule 613 that she told Mr. Willis previously that she didn't think he would have. It is absolutely too short a distance for Mr. Barron for the sound waves from the end of the gun to have hit the tympanic membrane of Mr. Barron's ear prior to the shots colliding with him. I know these are matters of technical proof, and I know it's probably dissatisfying to the audience for me to say it, but the bottom line is the law is the law. And Mr. Barron could not have reasonably apprehended the shot, and so we object to counts 2, 4, and 6 going to the jury on an A2 assault theory, leaving only the A1 intent to injure assault. We leave it to the court whether there is sufficient evidence for them to go to the jury on the intent to injure species of assault. But as to the A2 species of assault, the evidence, there's just simply no evidence from which the jury could infer Mr. Barron's reasonable apprehension. Secondly, I want to talk about counts. I'd like to talk about counts 3 and 5. Count 3, Your Honor, is the felony murder predicated on the criminal damage, and count 5 is the criminal damage itself. The elements of criminal damage under 16722B are knowingly and without authority interfering with any property and recklessly and thereby endangering human life. I don't remember how the end of the phrase is exactly said, but the point here is knowingly and without authority. Under Scott versus State, again, which is cited in our brief, when the General Assembly puts knowingly in a statute, it means that the state has the burden of proving beyond a reasonable doubt that the defendant is aware of the facts that would make her conduct unlawful. Here, and I know we talked about this a little yesterday at our preliminary charge conference, there is no dispute that Mrs. Barron was an owner of the property and thus the door inside of it, and a person has broad authority to dispose of their property as they see fit, including damaging it. And so I know, and I mentioned Gooch versus State to the court yesterday, which is sort of the closest case on point. It was a Court of Appeals case dealing with first-degree criminal damage to property. And the issue in Gooch, or the facts in Gooch, which arose actually out of Dawson County, were that the defendant, Gooch, and his ex-wife were in an argument, and they were fighting over a quilt, a blanket. The blanket was set fire to, the defendant set fire to the blanket, tossed it down, and the ex-wife had to jump over the blanket so as to avoid getting burned. The issue raised in that case was whether simply the fact that the defendant had claimed a property right in the blanket was sufficient to defeat a first-degree criminal damage charge. There was no discussion in that case of the scope of his legal authority. As for that case, what the Court of Appeals said, the Court of Appeals said two things. One, whether he has ownership of property, it is not an automatic defense on the facts of that case to the charge that he had an ownership interest, and arguably had an ownership interest in the property. The Court of Appeals also notes in Gooch that that there was evidence that even if he had asserted it, the jury could have found that he did not have an ownership interest because the wife claimed that the blanket was given to her outside of the marriage, and so it was not marital property. The problem the Court of Appeals had is that there is no property of another element in first-degree criminal damage as there is in second-degree criminal damage. Both offenses, I would note, derive from the former charge that persisted up to the 1960s of malicious mischief. And all cases of malicious mischief required property of another. That element was not carried forward expressly into the first-degree criminal damage charge. But questions of authority under 1613, paragraph 18, are if one is without authority, it means that one is not, or one is doing something that they do not have the legal right to do. And if one is knowingly without authority, it means they must be aware of the fact that they do not have the legal right to do it. So for one thing, a co-tenant in a home, and I feel the co-tenancy argument bubbling up behind me. A co-tenant in a home has full and equal rights to enjoy, profit from, alienate, dispose of their share, their total share of the whole, without the objection, without the permission of their co-tenant. And so what we're talking about here is the interference with property that is claimed to be without authority is a bullet hole. I mean, it's remarkably small and really does not largely change the value of the door or the value of the house. So for a person to not have the authority to damage their home if they have a co-tenant means that anytime my wife, actually I'm more likely to be the one who accidentally breaks something. If I break something, am I accountable to my wife? If I share a home with a person who is not my spouse, am I accountable for damages, for minor damage? If I did not ask permission before I did some damage to the property? The test, Your Honor, is a question of waste. A co-tenant might be able to collect in damages for waste, but waste, as a matter of law, is something that diminishes the essential value of the realty, and that's what we're talking about here, realty. Not just a blanket, but we're talking about a home, which is part of the realty. Or something that defeats sort of the future inheritability. And I'll say the cases on this are all old. We haven't had a real discussion in Georgia law of what the meaning of waste was since the early 1900s. But point the court, and I regrettably did not include this one in our memorandum, but I point the court to Roby versus Newton. That's 121 Georgia 679, 1905, where we discuss what the common law of waste is in Georgia and what will become the meaning of waste under 44-6-121A, which discusses the rights and obligations of co-tenants in property. The meaning of waste is some damage that destroys the essential value, the inheritability of the future state, not minor damage, not something that can be repaired easily. So for example, and this is old, but for one of the examples the court gives in Roby is that at English law, and I know everybody's groaning about to quote English law, but at English law, a co-tenant could not clear the field of a jointly owned piece of property, or a tenant cannot clear the field of a jointly owned piece of property because it was waste, because the landlord or the co-tenant, whomever also had an interest in the grain from the field, would have lost that value. In Georgia, that is not so because the field can grow back. It is only destroying the field. Distribution of mineral rights, if you take minerals out of the property, change the essential nature of the property. Shot in the door doesn't change anything, Your Honor, and there was no obligation. Ms. Mericle had a right to damage her own property, and no one had the right to tell her otherwise, and even if the court were to conclude that's not so, there's absolutely no evidence from which one would infer that she knew that fact. Because what we're asking people to do is anytime you're in a home, like, the contrary, unless there's some evidence, would be to think that, oh, well, whenever you're in a home, you know you can't dispose of it the way you want because you have to ask the co-tenant, your housemate, your spouse, whomever, permission for everything. That's not the law. When without authority is an element of a crime, as it is in, say, burglary, it must be proven by affirmative evidence. Which is why in burglary cases you always ask did you give so-and-so permission to enter your building, enter your home, walk on your, whatever. The without authority has to be shown that way, because it cannot be inferred. We cannot infer a criminal defendant's intent, which includes the criminal defendant's scienter, the knowledge of the truth of the fact. And there's simply no information that would allow the jury to infer that Ms. Mericle knew she was without authority, even if the court were to find that she was without authority. And for that reason, the without authority element does not survive in counts 3 or 5. And the remaining elements, that she interfered with property in a manner that was dangerous to human life, amounts essentially to reckless conduct. And reckless conduct that is the proximate cause of death is involuntary manslaughter. And so we ask that the count 3 go to the jury only on a theory of involuntary manslaughter, and count 5 go to the jury on only a theory of reckless conduct. That's my argument.
Judge, I didn't really hear anything that we didn't already argue yesterday and was denied, or 2 days ago, whenever it was. As to the aggravated assault, this is now the 3rd or 4th time we've had to argue the same exact thing. Those all sound like great closing arguments for Mr. Willis. We're here for a directed verdict that there is some evidence of these counts. We're not here for a beyond a reasonable doubt. We're not here for a demur. The demur's already been denied. The first directed verdict about the same exact thing that was just argued's already been denied. As to the aggravated assault, I don't know how many more times we have to argue the same exact thing that the state can prove either one of the aggravated assaults. We do not have to pick if the defendant intended to injure or if the victim was in reasonable apprehension of receiving violent injury. It's either or. The jury gets to decide. That's already been talked about multiple times with this case. As far as the actual evidence, there has been an overwhelming amount of evidence that not only this defendant did intend to assault Mr. Barron, but he also was in reasonable apprehension with the fact that he was hiding behind a locked door behind a wall in a defensive stance, while the defendant, based off her own testimony, said, "I've got a gun too, David," is what she said about 5 times or more on the interview, as well as on the witness stand, when she continuously said that she told Mr. Barron she had a gun. He goes up and retreats to the bedroom, locks the door, and hides behind a wall. That is an overwhelming amount of evidence, not only that she intended to assault Mr. Barron, but also that he was in reasonable apprehension of receiving violent injury. I quite honestly, Judge, do not understand why we are continuing to argue the same thing over and over in the hopes that Your Honor is going to give a different ruling. I would ask Your Honor to maintain the same ruling that Your Honor has consistently maintained in denying that aspect of the directed verdict. Again, as to the criminal damage to property in the first degree, I don't really understand where the defense is going as far as their interpretation of Gooch. My interpretation of Gooch, as well as just the bare words in the statute, is that a person commits the offense of criminal damage to property in the first degree when she knowingly and without authority interferes with any property in a manner so as to endanger human life. There's so much case law. The majority of the time where criminal damage in the first degree is used is when someone has fired a gun at a building, at a door, at an apartment, at a car. It's always a bullet hole. Is like almost every case that I look up as far as criminal damage to property in the first degree involves a bullet hole through some sort of item that damages that item and it has endangered a human life. That's like the majority of the time where that charge is used. So to say that it's just a little tiny bullet hole, that's not the point of this statute. The point of the statute is that she knowingly interfered with that property. We know that she knowingly shot the door, and we know that it was without authority because it's very clear in Gooch that when it's shared property, that it's just, and in any event, marital or family property partially owned by another is sufficient to establish the commission of the offense under 16-723A1. And then it continues to talk about all of the things that make this okay. There's been more than enough evidence in this case to show that the defendant purposefully walked up to the door, got 6 inches away, aimed the gun, and intentionally fired the gun. It has also been more than well established that Mr. Barron and her owned the property together. It's no secret that they owned the property together. So she knows that she's not the sole owner of this home and what's in it. There's also been text messages admitted where she was threatening basically to have some other man come in and basically kick Mr. Barron out, and they have this full discussion. I'm on the deed. You can't do that without me. I've got to sign title over. There's been plenty of evidence to show that Ms. Mericle knew she was not the sole owner of this property as well as all the contents within it. Mr. Barron was, at this point, the main resident of this house. She was just visiting on the weekends. He lived there full time. This was his full-time residence. She was just visiting for the weekends. They owned it together. They helped pay the mortgage together, so they shared this property. But there's been plenty of evidence in this case to show that this defendant knew that she was without authority to do whatever she wants with this property. She damaged the property, and it was in a way that endangered human life because Mr. Barron is dead. So if Mr. Willis wants to get up and argue all those reasons why they should not find this defendant guilty beyond a reasonable doubt of these counts, obviously he is more than capable of doing that. I know he's going to do a great job making all of those arguments to the jury. But as far as a directed verdict, Judge, we're not here for demur. We're not here to say that it's impossible for her to admit to this and it not be illegal because she didn't know without authority, all those things. We're not here for demur. We're here for a directed verdict for a second time, arguing the same thing, that she didn't have she had the authority because she owned the property. I just genuinely, Judge, I don't want to repeat myself again and again and again, so I would ask Your Honor to deny the directed verdict. There has been more than enough evidence as to all the counts in the indictment, and I would ask for Your Honor to leave it up to the jury to make the decision as to guilt or innocence to the charges in the indictment.
Defense, last word.
Ms. Bennett's argument is largely unresponsive, Your Honor. These are questions of technical proof based on the averments and the elements of the statute. As to the aggravated assault, there's no averment of words. There's no averment of threats. The averment is shooting the door. It has to be shooting the door that provides the reasonable apprehension, not anything else. If the state had wanted to allege by shooting the door and threatening, etc., then it ought to have done so. As Ms. Bennett said, it really is in the grand jury. She reminded us at the beginning of the trial that the charges are really just something she types up in her office. If Ms. Bennett wanted to allege more facts, she ought to have alleged more facts, but she didn't. The averment is shooting the door, and shooting the door in this case on these facts cannot be inferred to have provided Mr. Barron with any knowledge of anything. Now, as to whether this is the demurrer argument all over again, I'll admit it's related. But Your Honor, we've had to eat the fact that, that the court has allowed the state to go forward on 2 theories without specifying either. We're at this point, the state has gone forward on 2 theories without specifying either. What I'm saying, what the defense is saying, is that the state has failed as to one of those theories, and so only at best the other can survive. Now, as for the criminal damage case, I urge Your Honor to take it under advisement for 5 minutes. Gooch is short. Go read it. And I challenge Your Honor to find where the phrase "without authority" is discussed at all in that opinion. The only place in that opinion where it is mentioned is when the language of the statute is recited, but the discussion in that case is only about property of another without reference to the elements. And I'd like to point the court to one of our Supreme Court's favorite citations. In Georgia, it goes back to Albany Federal Savings and Loan Association versus Henderson, but the original source of the quote is Webster versus Fall. The Albany Federal Savings and Loans, 198 Georgia 116, and Webster versus Fall is 266 Georgia US 507. Questions which merely lurk in the record, neither brought to the attention of the court nor ruled upon, are not to be considered as having been so decided as to constitute precedents. Gooch does not control. The facts and the law bearing on the question of what one has the authority to do with respect to their own realty is the law. So I urge the court to take it under advisement, look at Gooch, see if I'm wrong. Thank you.
Thank you. I'm not going to rule right now. Next. Y'all ready for charge conference?
Yes, Your Honor.
Better copy of the instructions, let me know.
Thank you. This is, okay, sorry.
You want a third copy?
No, we're good. Do I want it to say as a lesser offense? And then I'm going to argue this. Okay. Huh? Yeah. Yeah.
The judge.
Judge, can we take the 2 firearms back into our office for the day?
Yeah.
Yes.
Thank you, Your Honor.
Folks, you're more than welcome to stay. It's an open court. We're going to do a charge conference. It is not the most interesting thing, so if you want to leave, that's fine. If you want to remain, that's fine too.
What's that?
No. No, just 2, sorry.
Third copy, there you go.
All right, let's look at verdict form V2. You'll note that the verbiage of beyond a reasonable doubt has been removed. Some other tightening up or cleaning up. I know that the defense wanted a different order. I respect that request, but you'll note it does not reflect that request.
I'm not going to lodge an objection.
And may I remain seated for this portion, Judge?
Yes.
Thank you. Ms. Bagwell.
Did you
and
need to
I-
grab something? That's fine.
Ms. Bagwell and I discussed this last night and this morning, and at this point, I think that we would object to the voluntary manslaughter lesser included as to the felony murder based off of criminal damage to property.
I apologize. We're talking about the verdict form?
Yes.
Okay. Go ahead.
And I guess, I mean, it's also, I guess, relevant to jury instructions, but I was just thinking about.
We're
it
not
because we were
there yet.
looking
That's
at
why-
the-
yeah.
At the verdict form, and I saw that, so I don't know if do you want me to wait?
Well, is it a substantive issue or is it the
I guess
form?
it's a substantive issue, so we can wait until we get to instructions. I just thought about it because I saw it on the form and,
Well, you can keep going. I just want to make sure we're on the same page.
okay. So I do not think that voluntary manslaughter is appropriate as to the criminal damage felony murder. The reason being is the point of voluntary manslaughter is basically to say that an individual, I mean, in this case, as it relates to the facts of the case, to say that Ms. Mericle shot the victim because she was overwhelmed with like the excitement of passion. essentially is what the purpose of voluntary manslaughter is. So saying she didn't have the malice to do what she did, she was just overwhelmed with this excitement of the passion, is voluntary manslaughter. And as to the criminal damage, the intent isn't necessarily to injure, it's the intent to interfere with the property. And so to say that someone was so excited that they interfere with property doesn't really make any sense based off of the facts of the case. Voluntary manslaughter is appropriate for an aggravated assault. So the voluntary manslaughter charge is under circumstances that would otherwise be murder acted only because of sudden, violent, irresistible passion. So Miss Mericle is not saying that she shot the door because of passion. She's saying she shot the door because she was trying to shoot the lock off. So it's a completely different intent as compared to aggravated assault, where we have to show there was the intent to assault. And then you can use the argument of she didn't intend to assault, she just was overwhelmed with this sudden, violent, irresistible passion. And so I do think voluntary manslaughter could be appropriate, lesser included as to the malice murder and the felony murder based off the aggravated assault. But I do not believe that based off of the intent required for the criminal damage, that voluntary manslaughter would be appropriate. Involuntary manslaughter is the appropriate lesser included because that goes more towards she did an act that was reckless. And so essentially it was reckless for her to try and shoot the lock off of the door, and as a result it endangered Mr. Barron's life. And so that's why involuntary manslaughter is the more appropriate lesser included for the felony murder based off of criminal damage, and not the voluntary manslaughter. They're two very different things. And so the state would object to voluntary manslaughter being given as a lesser included only as to count 3.
And on version 3, what page were you referencing?
Page 9
Thank you.
is the voluntary manslaughter charge. And then page 10 is the involuntary manslaughter charge.
In circumstances which would otherwise be murder, is the language of the statute. The court explained in Edge versus State in 261 Georgia 865 in 1992 is that to preserve
261 Georgia.
865 1992. Edge is the seminal case, but
Yes.
there are cases that flow from it. Is that to preserve voluntary manslaughter is a separate form of homicide. The question is whether the provocation or the passion due to provocation or is sufficient to mitigate the underlying action. Basically, is it part and parcel of the same assault? In Edge, it was an assault, but here what we have is, let's look at the facts, and it really is a fact-bound question. We know that Dr. Mericle was seeking to enter the room where David Barron was, and to the extent that the jury could find that she intentionally shot the door. And so it's the reckless endangerment of human life, that she intentionally shot the door. It's still an intent that could be mitigated by the provocation, or by provocation. And so the voluntary manslaughter charge is entirely appropriate as to all three murder counts. Just like it is for an A2 assault. Yeah, I mean, and actually, just like it is for an A2 assault, Your Honor, like as we've been talking about, there's no specific intent required for that assault. It really is just an intent to act. And in here, there's an intent to act. We wouldn't dispute that there's an intent to act. The question is really whether it was without authority, which we've put to the court. And then if the intent to act, if the act done recklessly endangered human life, then that's the gravamen of the offense. But it is absolutely the type of offense that can be mitigated. The offenses that can't be mitigated, possession of a firearm by a convicted felon. Where that's the predicate, that can't be mitigated. Gang activity, criminal gang activity, that's not the sort of thing that can be mitigated because there are elements sort of outside the act that make it a felony. But here, it's just another description. The state's looking for another description of the same act. And under those circumstances, it can absolutely be mitigated by provocation and passion. And we would submit that it is entirely appropriate to leave the charges as they are.
Okay, I've marked pages 9 and 10. Thank you. I'll review that.
No, not yet. My only other thing with the verdict form, Judge, that I thought about overnight as well, I would prefer for it to say guilty of the, like, for example, count 1, guilty of the lesser included voluntary manslaughter or guilty of the lesser included involuntary manslaughter. I did find a case, it was Flood v. State, that is 311 Georgia 800. It's a 2021 case, and the verdict form is what was being talked about there as well. And they also did, we the jury find the defendant guilty of the lesser included offense of voluntary manslaughter. We the jury find the defendant guilty of malice murder. And the reason why the state would be requesting that is simply just so as to not confuse the jury. I think the way that it looks right now, it looks like she's charged as to count 1 with all 3 things, and they basically get to pick one. And
Your Honor, I think I can.
Go ahead.
We have no objection to that change.
okay,
On which counts, please?
all of them. So count 1, 2, 3, anyone where there's a lesser included, which is counts 1, 2, 3, 4, 5, and that's it. 1 through 5. Right.
Okay, we'll work on that.
And that's it as far as the state for the jury verdict form, Judge.
Okay, thank you.
What about those first sentences in the one?
Would y'all like time to digest version 3 in its totality? Or do you just want to start going?
I think we can, what did you say?
We can do this.
I think we're fine to just start going, Judge.
Yeah. Happy to, Your Honor.
Okay. Page 1, I can't imagine there's any issue.
No, Your Honor.
No, Your Honor.
Page 2, no issue.
Nope.
Page 3, no issue. Page 4, no issue. Page 5, again, this is version 3, V3. No issue. Page 6, no issue. Page 7, no issue. Page 8, restating prior objections from the defense.
That's, no new issue, Your Honor, but
Yep.
same issues from yesterday.
Can I see V2? I went with the shorter causation issue versus the proximate cause. I apologize. Let's back up to page 4. It's a minor question or minor issue. Statement that the defendant allegedly made, parentheses, while in custody, close parentheses, has been offered. That's the way I intend to read it.
I would ask that that parentheses be taken out. Your Honor's already made a ruling that the defendant was not in custody when she made that statement. And so I don't think we should tell the jury that she was in custody, because there's already been a prior ruling that it was not a custodial statement in the Jackson-Deno hearing.
I wasn't going to say anything, Your Honor, but I can't disagree. The fact of custody is a question for the court. Voluntariness, however, remains a question for the jury.
Thank you.
We note, however, that the circumstances of the statement would be relevant, so where they are, what she was doing, what's going on. So that's, the jury can consider that. But the assertion of its custodialness is a question for the court, that the court has resolved, that at least that the court has resolved, and we may or may not take up later.
Noted. So that'll be removed. Thank you. That's off page 4. Version 2 was page 7. The proximate cause has been removed in favor of version 3. And I apologize. Now on page 8 of, nope, is that right? Confusing myself. I apologize. The date, not a material allegation, that was without issue, I believe. That's been removed.
That's fine, Judge.
Yeah.
As indicated, page 8 of the newest version, the issues noted on felony murder. Obviously, I have what the state brought up. I've highlighted that in purple as to 21041 and 21044.
And I was just looking at that, Judge. So I was trying to figure out a less confusing way to word it. I was looking at Long v. State, which is a 2026 Georgia Supreme Court case. And the way that the court worded it, I mean, obviously this wasn't like in a jury charge, but just the way that the law worded it was that when a jury renders a verdict for voluntary manslaughter, it cannot also find felony murder. I'm wondering if maybe we could try and word it similar to the way that the court worded it in this opinion by listing out, for example, if something about, if you find that the defendant is guilty of voluntary manslaughter as to count 1, the defendant cannot be guilty of felony murder as to counts 2 and 3, and then do the same thing if you find that the defendant is guilty of voluntary manslaughter for count 2, you cannot find, and kind of like do it like that. I don't know how the defense feels about that. I'm just trying to make it make a little bit more sense.
I support that.
Yeah.
Put on
Is that
the verdict
okay?
form. I'll put on the verdict form.
No, I mean, I don't think it should go in the verdict form. I think that it makes more sense to go in the jury charges, and I think probably both of us will be explaining that in our close anyway, but I just wanted it to be a little bit more concise. And so maybe just saying if the jury renders a verdict of voluntary manslaughter as to count 1, the jury cannot render a verdict of felony murder as to counts 2 and 3. Huh?
Is it also true?
No, we're talking about this.
I think,
They added this sentence.
I don't,
I mean, that's a proper statement of the law.
I was saying, Your Honor, I don't disagree with Ms. Bennett's statement in spirit, though I think it would be true if the jury, in an attempt to head off the inconsistent verdict, the possible inconsistent verdict problem, it would be true that if the jury found voluntary for any murder offense where it's a viable charge, that it would foreclose, that affirmative finding of provocation would foreclose a murder verdict on any of the other counts. I think it'd be true if the jury finds the defendant guilty of voluntary manslaughter on counts 1, 2, or 3, then it may not return a verdict of murder on counts 1, 2, or 3. So I think that's accurate. I just want to make sure that it's covered in all directions, not simply count 1.
No, I was saying list out each count. So then do for count 2, if the jury find, well, and we're objecting to voluntary being given for count 3. So really, from the state's position, I'm just talking about counts 1 and 2. So for count 1, if the jury returns a verdict as to voluntary manslaughter, the jury cannot return a verdict for felony murder for count 2. And then for count 2, if the jury returns a verdict for voluntary manslaughter, the jury cannot return a verdict of malice murder as to count 1. Like that, like going through and listing out each count, like defense says, from all sides, so that it's, to me, that feels less confusing. I don't know if Your Honor finds that more confusing. I don't know.
Submit you can do it if you want to file it, that's fine. All I care about is email your proposed language to everybody.
Yes, Your Honor.
Including Mr. Preston, including me.
Yes, Your Honor. Yeah.
And I'll say, and I'm not trying to be an ogre here, but within 2 hours of our concluding business today, because you'll need some final version tomorrow morning.
Yes, Your Honor.
Okay, that's it on that topic.
That was it. Sorry. Yes, yes, Judge.
All right, may I make a suggestion as to
Please.
21040 on page 9? That 21040 is an instruction that the Superior Court Judges Council has devised to try to circumvent the problem described in EDGE, that the sequential charging problem. I would suggest, not insist, but suggest that once the second line, in considering the malice and felony murder charges in counts 1, 2, and 3, it says you must decide. I think it is clearer to the jury to say you must first decide, because if they first decide it, then they would go on to the elements. But if not, the charge has been upheld as a proper statement of law as it is, and it's not necessary to do that, but I do think it's clearer, so I would suggest it to the court.
I like that addition.
Well, then object. I wasn't listening. I'm working on this.
We like it the way it is without the word first.
Understood. I'm going to include the defense suggestion as to the word first, please. It's on 21040. All right, moving on to page 10. I've highlighted in purple 21044. Pursuant to prior discussion.
I think that was the state's same concern with the introductory language, the may not be guilty of, but still be guilty of. And I included the language in the hope that we could sort of be clear as to what things related to. I thought it was going to be helpful in guiding the jury through its decisional process. I'm happy to entertain other suggestions. But I also think that this is different from the voluntary issue because of the structural relationship between involuntary and the greater charges. I mean, no. So we like it the way it is, but I'm happy to, I'm not gonna have heartburn if we want to tinker with it.
Okay. If anyone's got any suggestions, email them. 22021, I don't think there's any issue on that.
No new issue, Your Honor.
Yes, fair point. Defense wanted 22022, that has not been removed. Oh, sorry. I misspoke. Thank you, Mr. Preston. So as you will note, and I apologize for assigning, 22023 is gone, 22022 remains.
We'll lodge the formal objection at the statutory time.
Thank you.
I just think that needs to go. 'Cause it's not okay.
What, this top part? That's what we've been talking about? I just proposed to
Okay.
just fix it. I mean, I think we need to explain it to you.
26820, obviously separate and distinct from defendant's issue at close of rebuttal.
It's the statutory language, we have no objection to that. And then we requested the line at the top of page 11, so.
Okay, thank you.
That's added.
22310, I don't think there's any change on that.
Are we objecting?
Judd, I'm sorry.
Yep.
To 26820, we would just request the pattern charge. We would object to any additions to the pattern. So they can argue all day without authority. We've already established that, but it's not in the pattern for a reason, and I don't believe that Your Honor should instruct on it. I think that it's something that they can argue as far as why she's not guilty beyond a reasonable doubt, but we would request the pattern be given.
I'll look at it again.
Yes, Your
I
Honor.
understand the state's position. Assume it's the way it is right now. $240.30. anything on that, especially related to number 3?
No, Your Honor.
Not from us, Your Honor. It was our suggestion.
I think the next page is without any dispute. Aggravated sodomy, you'll note, and I did take out the rape. I'll hear from the defense, or you can save it for later.
No new argument, Your Honor, but we'll lodge our objection at the statutory time.
Reasonable beliefs, no duty to retreat, threats justifying homicide, excessive force, revenge,
Back to page 12, the justification, if we could take out rape in that as well. Aggravated assault by strangulation, aggravated sodomy, rape, and malice murder are forcible felonies.
good catch.
We'll lodge our objection at the appropriate time.
Reasonable beliefs. Doesn't have any language in there about the defendant's unique circumstances, which is in our, better person's charge. Right. We didn't have to complain about it before because we had a separate charge. And then we just
Okay,
instead of 310, 12.
Yeah. So, actually, Your Honor, I think we,
I'm sorry, hold on one second.
apologize.
Did you do that right now?
I did.
Wow. The record reflects you didn't need 2 hours.
I have an hour-long drive after this. I figured it was better to do it now than later.
Everyone.
I sent it to you as well.
Apparently, everyone received an email. We'll have to do that right this second. I mean, we
Yeah.
can, I mean, I don't have a problem with it. Let's get through here and then retrace.
So, Your Honor, I think on page 13, 31012, we had asked, and this is sort of related to, I think, the alleged violence charge on page 14. We had asked, I saw the court has dropped PTSD from the instruction. It's what it appears, unless I'm missing something.
I do not believe you're missing.
All right, but if that's the case, either one charge or the other, one will lodge the objection about PTSD at the appropriate time, but one charge or the other should reflect that it's a reasonable person in the defendant's circumstances, which was, we had no objection at 31012 yesterday because our proposed charge included the defendant's circumstances. Now it appears nowhere in the instructions.
Okay. Fair point. So what modification are you requesting?
I'm going to have to tinker with the language, but basically the belief must be reasonable for a person into the defendant's circumstances, with the defendant's history, experiences, et cetera, because that's what the SJA language is there. The original language is in our supplement. Hold on.
Is this the pattern?
60s.
So, 3 times 12.
Yeah, so in our supplements, request number 67, in sort of the middle of the paragraph on the top of page 5, the standards whether the circumstances were such that they would excite the fears of a reasonable person possessing the same or similar psychological and physical characteristics and history of abuse as the defendant, and faced with the same circumstances surrounding the defendant at the time the defendant used force. So
Go ahead.
no, I understand it's not part of the pattern. It was part of, as we noted yesterday, the battered person syndrome pattern, which has itself been obviated, but the issue, the from the defendant's perspective, reasonable person under those circumstances.
Come on
is
up.
still part of the
I
law.
was just thinking in my mind that we need to change that drum, so good work. Thank you. Or cartridge or whatever it is. Thank you. Go ahead.
That was our point, Your Honor, that it is not simply a reasonable person, but when we're bringing in the history of past abuse, then it is a reasonable person in the defendant's circumstances with their history, the history of abuse. So I'd ask that that be included.
I'll look at that. Thank you. Go ahead.
We would object, this is pattern 31012, is the pattern for reasonable beliefs explaining what defense has done, is taken the pattern for reasonable belief and then added a different unrelated pattern charge to the reasonable belief. And we would ask that Your Honor give the reasonable belief explained as it's given in the pattern and not to the defense is picking and choosing sentences from the battered person syndrome charge and putting it into the reasonable belief explained charge. And again, battered person syndrome is not relevant in this case. And I believe it would be improper for us to basically be combining pattern charges. And we would just ask that the pattern be given. They can argue whatever they want in close. But as far as instructions that fit the facts of the case, battered person syndrome was never mentioned and does not fit the facts as to this case. And so we would ask Your Honor, give the reasonable belief explained as pattern has it.
Your Honor, I'm not going to rehash the same things I said yesterday about the fact that we didn't ask for the words battered person syndrome, but the evidentiary framework is still, the framework of relevancy is still pertinent. But I would also note from the preface to the Georgia Suggested Pattern Jury Instructions, Volume 2, about halfway down, I guess the third paragraph in, these instructions are submitted as suggestions only. Your Honor, the instructions are not the law. The question is to tailor the instructions to the law as it applies to the case. I know Ms. Bennett does not believe that these issues apply, but they absolutely do. The premise needs to be included somewhere. If it is not in that instruction, the jury needs to be told that to take into account the defendant's circumstances, a reasonable person in the defendant's circumstances with a history of abuse that she has suffered. And also we would note, we would object to the absence of PTSD from that list.
Understood. Thank you. I'll look at that. Thank you. All right, back to, I believe, page 14. Is that where we are? 14?
Yes, Your Honor.
Thank you. Other than the PTSD parts, anything else we need to talk about?
Just the same objection with the court's elision of the reference to rape and the definition of forcible felony at the top of page 14.
Meaning that rape's not included in there, you
Yeah.
want it, got it?
Yeah, yes.
Sorry, thank you. Got it. What else on 14?
Nothing from the state judge.
Nothing in addition to what's already been stated, I think.
And I can't imagine anyone has anything on 15.
No, Your Honor.
We have 1 second with Mr. Willis.
Yeah, more than that.
Your Honor, we think that the 3.60.10 really is no pertinence to the case at this point. No one's alleged that there's been involuntary, sorry.
Is she okay?
Let's find out.
Everyone's good? Okay, I'm sorry. That's fine. I just didn't know. All right, go ahead. What was your issue? I'm sorry.
So I don't think that, I think that 3.60.10 is.
Page?
Page 14, bottom of page 14.
Thank you.
Certainly. It's unnecessary. There's been no assertion or really discussion of intoxication in a way that undermines anybody's mens rea or the
So take it
capacity
out?
form. I think it should be out.
I would ask it stay in. I elicited testimony on cross of the expert about all the medications that she was taking and the side effects that can be caused by taking all those medications with alcohol. And so I think that it is relevant to make sure the jury understands that taking all those medications with alcohol, if it causes negative side effects, it's not a defense. And so I think that it is still relevant to the facts of the case.
Okay. I'll look at that also. Thank you. What else?
Stand on our objection.
All right. Anything else?
No, Judge, and like I said, I emailed the suggestion for the voluntary and involuntary charges.
All right. Mr. Preston, I will
My
work a little.
suggestion? Yeah. You want me to email it to you?
I've got it.
We'll work a little bit more on this.
Thanks.
Y'all got a copy?
We do now, Your Honor. Or I have it in email, but
And it's like-
this is lighter than my iPad.
Yeah, and I objected to 3. But obviously, if the judge gives 3, then it would just be the same thing, but adding in more counts. If you find the defendant acted such provocation of count 3, you would not be authorized for counts 1 and 2, and then same with, you know what I mean?
Yep, yep.
Okay. So basically, just like a third paragraph, if Your Honor gives the voluntary for count 3.
If the court's comfortable with it, so are we.
Okay. We'll head in that direction.
Your Honor, may I think I said yesterday, or asked if I could defer some specific ruling, up or down rulings on specific requests.
Would you like to do that now?
I would, if Your Honor would indulge me. At least let me list.
I will indulge you. How long do you think it might take?
I think I can do it in less than 5 minutes. Because I think I want to go through and list the numbers, and
What are we doing?
I want some
Wants an up or down ruling
up and down rulings
on
specific
request to
requests.
charge.
Okay.
Just for purposes of the record.
Yeah.
All right. So I'm working backwards, Your Honor. Our request number 67, which was in our supplemental, and that was our request for an instruction, or one of our alternative requests for instructions regarding the PTSD, family violence, the SJA evidence. For the same reason, we'd asked for an up or down on 37, which was their first stab at that instruction.
I'm
So-
sorry, you say 3-7 or 6-7?
Both.
Okay, so let's go one at a time. I apologize. So on 6-7, you're asking for up or down. So for the record, that's denied on 6-7.
And 37 dealt with the same subject matter. We had two
And I
attempts.
apologize. 3-7, is that in your
That's in the
first
initial,
request? Yes.
our initial request, page 38.
Yes, thank you.
And similar in proposal, it deals with the same subject matter, worded a little differently.
So you're requesting a ruling on 3-7. Your request is denied, or your request to charge is denied.
Understood.
On 6-7 and 3-7.
All right. And, Your Honor, I would also ask for specific rulings. Well, let me get down to it. I'll try and- Yeah, our definition of felony murder, I know what the court has said, but I think proximate cause. I think our specific requests, 39 and 40, which deal with the elements of felony murder and the Apprendi issue that I've raised before.
I apologize. Is it, you said request number 39?
Request number 30, they are on pages 41 and 42 of our initial submission. They deal with those, they deal with the Apprendi issue that I raised for the court before.
39, request to charge is denied. 40, request to charge is denied.
And then similar request with respect to, hold on, or similar, I swear the next time I do this, I'm going to index them for myself. I would ask for similar, well, I would ask for the courts to decide. I know the court has included the definition without authority. We had some additional requests regarding without the meaning of authority under these circumstances. 48 in specifically.
I apologize. Charge number 48?
Request 48, page 50.
Thank you. Understood. Request to charge 48 is denied.
And not to skip around too much, the court has really, I guess, already ruled on our request number 47 by excluding it.
Request number 47.
Well, I guess page 47, request 45, but the court's already ruled on that by excluding it. We've noted. And I think that was all that I wanted to make sure of for the
Since
record.
I'm here, request 45 is denied.
All right. Thank you for your time, Your Honor.
No, thank you for yours. Anything else we need to talk about on jury charge issues?
Not from the state, Judge.
Did y'all have something?
With respect to the ones that you're still working on, is the court intending to send an email or something tonight, so you know what the trial is moving to tomorrow?
Very likely, the final version will be emailed to y'all within a reasonable time of conclusion.
And as you said yesterday, the state typically will open and conclude. I always like to ask if that's their intention, because otherwise I have to set up first. So are you opening and concluding? Okay. I may try to get, I'll just contact Kenny from IT in case we have an issue on the switch. But I will quote that. I just want you to know that's the only thing I have concern about. Thank you.
Let me get my stuff organized. All right, I appreciate everyone. Y'all done an excellent job up to this point. Sheriff's Department, I have noticed that after lunch, we got to not full capacity, but pretty robust attendance. And typically, people tend to come in more for closing arguments and verdicts, et cetera. So I'm want to make sure we're on the same page. Row 1 is typically for court personnel and lawyers, et cetera. Row 2 is labeled that as well. Is there, and I'm not questioning it, is there a safety and security issue as it relates to 2? Okay, so 2 will remain court personnel and lawyers. Okay, so FYI, you know, I don't want to start excluding people, but there is a live stream, and I'm not saying we're at that point, but I'm going to ask my bailiffs and maybe the sheriff's department, if it gets pretty crowded and lawyers start piling in the back, maybe ask them to come to the front. And I understand that sometimes they want to leave, I get all that. But if they hang out in the back, that could be something that could otherwise be used for the public that they wouldn't otherwise have. So if they could gravitate more towards the front, and I'll ask the bailiff to do that as well. The door, so I would imagine at some point, and again, I'm not a juror, I'd imagine at some point they may want to look at the door. So I would imagine that would be bringing them all out here to do that. We could put it in the jury room.
Yeah, I think we should just put it back in the jury room with them, Judge.
It was tendered, so I don't.
I understand it was tendered. I mean, I had a very large truck bumper tendered once too, and the court reporter begged me to take a picture of it and not make her keep it for the rest of her life. So yes, it has been tendered. I just want to make sure we're all on the same page as far, that's why I'm bringing it now versus.
We can make sure that we have the proper tools to wheel it back into the room with the jury, but we would ask that the door go back into the deliberation with the jury.
But we'll take a picture of it so the court reporter
Yeah.
doesn't have
Take
to
a
keep
picture
it.
of it for court reporter.
So that was, yeah.
Purposes.
So yes, so the good news was the bumper was on a civil case, and I'll be honest, I'm not an expert on, I think this goes back to the sheriff's department. I don't know. I don't think the court reporter is going to keep a Beretta and a Glock, et cetera, in all seriousness. We'll let the court reporters debate all that, but just from what do we envision? It's make them ask for it. I tell them, hey, if you want the door, ask for it. We just go ahead and ship it back. It's not a big room, so that's why I'm asking.
So go ahead and ship it back with them, with all the other.
I'd send it
evidence.
back, Judge, respectfully.
Okay.
Unless they ask them to have it removed, which we don't have a problem with.
Yeah, unless they ask for it to be removed, I say when we give them all the rest of the evidence, we just ship it back with them as well. They can lean it up against a wall, they can put it on the floor.
Okay, there's obviously a minor to moderate safety and security issue with it tipping over. It doesn't appear, I've not touched it. It doesn't appear to be a super heavy door, but obviously y'all have had a makeshift base for it. So taking that in consideration, I know on some level, I mean, people have been using gloves. I mean, do we direct the jurors if you're going to touch it, use gloves?
Yeah, we'll make sure that they have gloves, Judge. I'm gonna move it there, thank you. Yeah, we'll make sure that they, use gloves if they're gonna touch any of the.
So I'll give them sort of a overview of that issue. Any other practicality things we need to tell them?
Not that I can think of at this moment, Judge.
As a- I'll very likely also tell them that, they're going to have all the evidence, but if they wanted to review any audio or video, they need to come back into the courtroom to do so, which is my standard operating procedure. I'm not the only judge in Georgia, so maybe somebody does it different, but that's the way I've done it.
Yes, Your Honor.
Any other practical pointers that we need to consider?
No, Your Honor.
Door, evidence, nothing?
I think so.
Gloves. Okay,
Thank you.
Thank you, Your Honor.
see y'all tomorrow. Thank you.